Good afternoon. On behalf of the Center for the Study of Law and Religion at Emory University, I welcome you to this online conference on the promise and perils of religious arbitration, new research, emerging trends, and practitioners' perspectives. I'm Dr. Shlomo Pill, and I'm the managing editor of the Canopy Forum, as well as the Paul and Marion Kuntz Scholar and Senior Lecturer in Law at Emory Law School. We have the honor and pleasure of hosting today a distinguished group of 20 of the top scholars, practitioners, and experts on religious arbitration and dispute resolution in the United States. They include representatives from a broad range of religious communities, Jewish, Christian, Muslim, and Sikh, who over the next 90 minutes will be sharing their insights and experience with us. Each presenter has written a short article on a specific topic or question about religious arbitration, conciliation, and dispute resolution. These articles will be published on the Canopy Forum website in the coming days and weeks. Many of them speak to the promise of religious dispute resolution, its ability to design a path that encourages conciliation between disputants, that can provide broad community support to help prevent and settle disputes that do arise, and that can adapt religious and cultural norms to the realities of the US legal system and the expectations of American society. Other articles examine the potential perils of religious arbitration, such as whether religious arbitration violates the Constitution, how the law should deal with power imbalances and protect vulnerable parties, and the danger that anti-Sharia laws pose to religious arbitration, and not just Muslim communities, but to all religious communities. Each speaker today will give a 4-minute presentation on a key argument or insight about the forms and functions of religious arbitration in the United States. What is it? Is it good? Is it bad? Is it legal? And much, much more. These presentations will challenge you to think in new and different ways about the promise and the perils of religious arbitration. Speakers are grouped together into 4 panels. A moderator will introduce the panel and the speakers, which are also listed on the Canopy Forum website. Thank you all for joining us today. And now let me introduce Dr. Leanne Bambach, the organizer of this event.
Good afternoon. I'm Leanne Bambach, and I am a senior fellow in Islamic law at the Center for the Study of Law and Religion here at Emory Law School. The title of today's program refers to religious arbitration. In fact, however, most religious communities emphasize not just arbitration of conflicts, but conciliation and mediation, with arbitration often only used as a last resort. So many of today's presenters will be speaking about dispute resolution more generally, not just arbitration. Also, our condensed format limits our panelists' ability to engage directly with one another or audience members. However, I encourage you to submit questions and comments on the Zoom chat feature. These will be shared with the speakers after the event. Turning to today's presentations, our first panel is Foundations of Religious Arbitration and Dispute Resolution. And I am very pleased to present our very first speaker, Professor Ronald J. Colombo of Hofstra University School of Law, whose presentation is entitled A Legal Analysis of Religious Arbitration.
Well, thank you to the Canopy Forum for hosting this event, to Lee for inviting me to participate, and to my fellow presenters, and to those of you in our audience. With my time this afternoon, I shall provide a high-level overview of religious arbitration, touching briefly upon many subjects that others here will expand upon in much greater detail. Arbitration is the private resolution of disputes conducted outside of the state's judicial apparatus. Religious arbitration is the private resolution of disputes based upon the values, principles, and procedures established by a particular religious group. Now, religious arbitration has been around since at least biblical times, which is quite understandable. For few things touch more deeply upon a community's norms and values than the manner in which it adjudicates conflict between and among its members. The prevalence of religious arbitration in the United States has waxed and waned over the ages, but is currently on a bit of an uptick, both in frequency and in attention. This is probably due in large part to the growing disconnect between religious communities and the secular courts. Now, religious arbitration arises primarily in 2 contexts. The first is among believers who belong to a particular congregation. One of the conditions of membership in the congregation might be a pledge to resolve any disputes within the congregation via recourse to religious arbitration. Less common and a surprise to some are religious arbitration agreements within the context of commercial transactions. A religious merchant may, for example, include as a condition of sale an agreement on the part of its customers to submit any dispute arising out of their transaction to religious arbitration, regardless of the beliefs of its customers. Now, as mentioned, religious arbitration is predicated upon particular values and principles dear to its religious tradition. These values and principles might not align well with those of our prevailing secular society. Moreover, instead of a neutral judge, in theory at least, claims resolved via religious arbitration are heard before an arbitrator or a panel of arbitrators chosen in ways that some fear do not safeguard their neutrality. For these and other reasons, religious arbitration has no shortage of detractors. Some of its critics have even challenged the legality of the practice of religious arbitration. All private arbitration, including religious arbitration, is governed by the Federal Arbitration Act, the FAA. It is the policy of the FAA to uphold and enforce arbitration agreements. Such agreements are essentially subject to the laws of contract and can be struck down for any of the reasons that a defective contract could be struck down for, such as coercion, duress, unconscionability. The FAA adds to this additional safeguards, affording relief to those whose arbitrations are marred by fraud, corruption, prejudice, and even miscalculation, among other shortcomings. I look forward to what my fellow presenters here today have to say about this, but it is my opinion that the safeguards already contained within the FAA address the most common concerns raised about religious arbitration by its detractors. The FAA makes no mention of religious arbitration per se, but it is commonly understood that its provisions apply equally within that context. And such would necessarily be the case, as per the First Amendment to the US Constitution. For the free exercise clause of the First Amendment precludes government from treating religious activity inferiorly to other comparable activity. This principle certainly extends to religious arbitration. A carve-out from the FAA, pursuant to which religious arbitration were held to more onerous standards, or perhaps forbidden altogether, would not pass constitutional muster. Only and unless all forms of private arbitration were banned, could potentially religious arbitration be foreclosed. Thank you.
Thank you so much for that. Our next speaker is Chaim Seyman, but I am not sure he is here. Chaim, did you manage to get here yet? So we are going to skip him and hopefully come back if he is able to join us. I'm hoping next, Candy, if you could help us out here. Candy McCune is an attorney and experienced Christian conciliator, and she's going to be talking today on guiding Christians to the best conciliation process and preparing them to participate well in it.
Yes, thank you, Leanne. And yes, I work with Christians. And what that means is that the Bible, Scripture, is the supreme authority governing every aspect of our conciliation process. What's conciliation? It's a process for reconciling people and resolving disputes out of court in a biblical manner. It's a conciliatory process rather than that adversarial process in which I was trained as a lawyer. Now, first, I try to help people recognize the problem is really a problem. Fight or flight, they don't work as solutions to disputes, especially the ones that have them still roiling up inside. And hating another person, that's the poison we drink, wishing they would die. That doesn't make sense either. And that's not a solution we desire, truly. So helping them recognize the problem is really a problem comes first. Secondly, when a person recognizes that their usual methods of dealing with a dispute or conflict are not working, we start with the only part they truly control, themselves. What is their part in the dispute? Do they have ownership of some contributory factor? This is major work to be done, and it starts with one-on-one coaching. Now, this is the kind of coaching that often continues even during a mediation in a Christian setting. With all the parties, I help them examine the circumstances, the dynamics of the people involved. Who is really the focus? What is really the focus? And what process options are available? Then we select the process that best fits their situation. And hopefully, at that point, we're able to set it in motion. What are the processes? Let me just start with that coaching. It's a one-on-one activity. It involves working with that individual, each of the parties, to draw out what the underlying reasons for that dispute are. Whatever matters of the heart are impacting attitudes, motives, or actions that are inconsistent with Christ's commands and teachings and that are dishonoring to God. Mediation, it's a relatively informal and totally voluntary process. That's where a mediator facilitates the communication between the parties. Mediators are concerned as much with reconciling the parties as helping them settle their substantive differences. The goal is to assist the parties to find their own best solution to the dispute. Arbitration, that is a more formal process where the arbitrator acts, it's in a different role as a judge. Their decisions are also legally binding. Going directly to an arbitration without trying mediation first is usually not advisable. Another option is mediation/arbitration. The parties will agree to mediate first, and if unsuccessful, either on one issue or more, the parties are legally obligated to proceed to arbitration on those unsettled matters. Now, as you may imagine, just getting through the initial stages and identifying the best process, it takes some time. We establish passport. We figure out a lot of things that need to be addressed before we ever get into the room together. But especially if you have one side who's not really wanting to participate, this is not easy. And I will tell you, that's most often the case. So the initial consultation and then the one-on-one coaching of each of the parties, that's all very crucial in getting a process selected and in place. And it also starts the individual work in each of the parties that is going to be absolutely necessary to be done for the process of mediation or any joint meeting together to have success. Now, one of the biggest hurdles I find is the belief of parties that mediation always results in a compromise, a splitting of the difference. And that's just not true. It's amazing when people recognize their contribution to the problem, which they may have totally missed all the way up to contacting me. They are ready to hear the other side. They listen. And it is a wonderful situation when workable solutions appear from their hearts. The generosity of these solutions often astounds me. And the rejoicing over the reconciling of relationships, that's a total win for all, but especially the Lord. The key is the gospel in Christian process, and it's spelled out and applied in Scripture. We follow it all the way through. Thank you.
Thank you so much. The next speaker on our panel is Professor Michael A. Helfand of Pepperdine University School of Law, whose contribution is entitled, "Who Arbitrates? Arbitration Qualification Clauses in Religious Arbitration Agreements."
Good morning for me, good afternoon for you. Religious arbitration is, at its core, defined by two related features. One, decisions are rendered by religious authorities who, two, adjudicate disputes in accordance with religious laws, rules, and values. Religious arbitration agreements typically reflect these two elements by including both arbitration clauses and choice of law provisions. But like parties to arbitration more generally, parties to religious arbitration sometimes also incorporate arbitrator qualification clauses. Such clauses are relatively common in arbitration agreements and allow parties to choose the kind of decision makers they believe are best suited to resolve the dispute. They can require arbitrators to be judges or CPAs or anything else the parties think is important. In this way, they stand at the very center of arbitration agreements. As a general matter, such clauses can generate legal challenges, for example, when they unlawfully tilt the scales of the arbitration in favor of one of the parties. Thus, An employer might draft an arbitration agreement to be signed by employees where any disputes would be resolved by individuals who are actually supervisors within the employer's company. In the extreme, such clauses can render the contract unenforceable because it fails to satisfy the basic requirements of arbitral neutrality or because it renders the agreement unconscionable. But arbitrator qualification clauses in religious arbitration agreements present an added wrinkle. In religious arbitration agreements, arbitrator qualification clauses typically incorporate religious criteria. Therefore, determining whether or not an arbitrator qualification clause might trigger partiality or unconscionability concerns typically requires determining the theological meaning and impact of these criteria. The problem is that the Establishment Clause is understood to prohibit judicial interpretation of these sorts of religious questions. This core conundrum has been front and center in recent controversies over the Church of Scientology's use of religious arbitration agreements. To see how, consider the case of Garcia v. Church of Scientology. Maria and Luis Garcia, former Church of Scientology members, filed suit in federal district court against the Church of Scientology, alleging fraud and breach of contract claims. When the Church of Scientology filed a motion to compel arbitration of the dispute, the Garcias claimed that the arbitration agreement was unconscionable, in part because of the arbitrator selection clause, which required that all the arbitrators, quote, be Scientologists in good standing with the mother church. The Garcias argued that they had been declared suppressive, and Scientologists in good standing are prohibited from communicating with suppressive individuals. Both the district court and the 11th Circuit rejected the claim. Resolving such questions would require judicial assessment of Scientology theology. How else could a court determine the impact of an individual being declared a suppressive? But such an inquiry, the court said, was prohibited by the First Amendment, and so the court enforced the arbitration agreement. What should happen in such cases? One possibility is, instead of contesting the underlying fairness of such provisions, parties might instead argue that enforcing the provision itself constitutes a violation of the Establishment Clause. See how, consider the example of in matter of Esther Ismailoff, where a New York surrogate court refused to enforce an arbitrator qualification clause that required selection of, quote, 3 persons of the Orthodox Jewish faith. The court concluded that enforcing such a provision would violate the Establishment Clause because it would require judicial determination of a religious question, whether the arbitrators were Orthodox. One can imagine making a similar argument regarding the Church of Scientology arbitration agreements. Determining whether someone is a Scientologist in good standing with the mother church might very well require delving into religious questions. Therefore, if the parties disagreed over who qualified as a Scientologist in good standing with the mother church, a court ought to refuse enforcing the provision and, in turn, strike it down from the arbitration agreement. Courts are yet to go down this alternative path. But if we are both to ensure the enforcement of religious arbitration agreements and to police those agreements for partiality, that may need to change and change soon. Thank you.
Next, Courtney Freer will be introducing the second panel for today.
Great, thank you so much. I'm Courtney Freer. I'm a senior fellow at the Center for the Study of Law and Religion, as well as the Provost Postdoctoral Fellow at Emory College. It's my pleasure to introduce you to today's second and longest panel, Religious Arbitration and Dispute Resolution in Action. This panel's 7 participants come from a broad range of religious traditions. Some are scholars of religious dispute resolution, some are practitioners, and not a few of them are both. Each of them will be presenting on some aspect of dispute resolution as it is practiced within a specific religious community in the United States, or new developments that seek to enhance community members' ability to resolve disputes in a religiously faithful way. Our first speaker is Professor Charles Reed Jr. of the University of St. Thomas School of Law, speaking on the canon law of arbitration.
Ms. Freer, or is it Dr. Freer?
Dr. Freer.
Dr. Freer, thank you so much for that introduction. And I've written on the issue of arbitration in the Catholic Church, and it turns out to be a rather complicated story. But I will try to break it down in a digestible format using a series of hypothetical examples. And I'll begin by saying that there are three basic avenues for arbitration or conciliation to take place within the Catholic Church. One involves the arbitration or conciliation of what are called administrative acts, the decisions made by public authorities in the church, bishops, let's say, or pastors, people holding office within the church. Others are matters of private dispute resolution, making use of Catholic auspices to arbitrate disputes. And finally, what I find the most fun, most intellectually entertaining, if you will, is the issue of papal arbitration, particularly in the world of international disputes. But I'll begin with administrative arbitration. And let's take a typical example of an administrative act. A bishop is reorganizing the school system of his diocese because of financial exigency. Frequent occurrence these days in the United States. The Code of Canon Law gives parents the right to educate their children in the faith, gives children the right to receive such an education. These are positive grants by the Code of Canon Law. It also gives the bishop the authority to see how to perform these, to carry out these functions within the diocese. You could have, and there are avenues of litigation where you could take these sorts of cases to Rome. It's difficult, it's obscure, it's expensive, it is vastly time consuming. You don't want to do that. But Canon 1733 of the Code of Canon Law allows for conciliation. It's non-binding conciliation, but it allows for conciliation. And bishops in such situations are encouraged to take that path, sit down perhaps with parent groups, sit down with affected constituencies, and try to come up with a conciliation, a settlement of the dispute. Again, non-binding, lacking legal authority under canon, legal bindingness under canon law, but a means of trying to resolve what would otherwise be a very tension-filled and often angry process. So that's one approach. Then we have also Canon 1713 to Canon 1715, which involve the arbitration of private disputes between private parties in the Catholic Church who may want to make use of specifically Catholic arbitration. There are two codes of canon law produced in the 20th century, 1917, 1983. The 1917 Code of Canon Law clearly contemplated a European situation where arbitration and dispute resolution often took place under what are known as concordats. Agreements, treaties really, between the Holy See and relevant European nation states, allocating judicial responsibilities often involving Catholics. And the Code of Canon Law was written with that in mind, the 1917 Code of Canon Law. 1983 Code of Canon Law is broader, more generic, lacks the kind of European focus that the 1917 Code of Canon Law did. But I nevertheless explore a couple examples of situations where we could see arbitration take place. Say, for example, a labor dispute or an employment dispute within an archdiocese, where we have perhaps a clause calling for religious arbitration, or perhaps the parties decide to seek religious arbitration of their dispute. Or another example I give in my paper, a Catholic couple, a seriously Catholic couple who divorce but want the property settlement that they reach to be handled not by the judiciary but through religious arbitration. A final example I give, because the Code of Canon Law does not limit this arbitration to to Catholics. A playful example I give is I call the case of two Protestant pastors who have a problem, let's say, with the example I give is little involved, but a case of tree blight. Their properties are adjacent, and you have a case of tree blight, calling for the removal of trees that are owned in common by the two congregations, and how do we allocate costs there? And the example I give is rather intricate, but they are friends with the bishop, and they sit down with the bishop, and they arbitrate it through a court of canon law. Courtney,
Thank
you
you so
look
much.
like I'm about to run out of time.
Sorry, Professor Reed. This is fascinating. I'm sorry to cut in.
Then let me just finish real
Okay,
quickly
sorry.
and say the third example is papal arbitration of international disputes. And there I give the example of a famous 1940s case involving Canada and the United States called the Trail Smelter case, involving environmental degradation, externalities, and all sorts of things like that. And I suggest that maybe papal arbitration could help in the case of Catholic countries that encounter these sorts of things. Anyways, thank you, and I went over time. I'm sorry.
No, thank you so much. Next, we have Azam Nizamuddin, who's an attorney and general counsel of the American Trust Corporation, North American Islamic Trust, who will speak about religious arbitration in mosque disputes.
Good afternoon, everyone. I'd like to thank Professor Bombach for convening this conference and to the other organizers and my fellow panelists as well. My paper encompasses both the issues involving mediation and arbitration in the mosques and institutional context, but also some in family law as well, because there's been a growing sort of development in that particular arena of family law disputes. Now, private alternative dispute resolution has been going on in the Muslim community really since the inception of Islamic civilization. The Muslim community, both scripturally, but also from a state perspective and a civilizational perspective, has encouraged disputes to be resolved outside of formal litigation. And these were historically and even contemporarily known as tahkim, which is arbitration, sulh or wasata, mediation. Now, this dispute process actually had been formalized historically into what's known as Islamic law or Sharia. And specifically, the concept of tahkim are found in the Quran, particularly chapter 4, verses 35 and 58, specifically a verse that says, if you anticipate a split between a couple or a party, appoint a mediator from one member of the family to another. And if they desire reconciliation, God will restore harmony between them. Furthermore, indeed, verse 58 says, indeed, Allah commands you to return trust to their rightful owners. And when you judge between people, judge with fairness and nobility. So the operative words here is فَبْعَثُوا حَكَمًا مِنْ أَهْلِهِ, as well as وَإِذَا حَكَمَتُمْ بَيْنَهَا. So hakim, the role of hakim, which later on becomes formalized into different roles within the state hierarchies, judge or mediator. In addition to the Quranic basis, there's of course the example of the Prophet Muhammad, particularly in his role as a community leader in Medina after the Hijrah movement. You have him really specifically not only mediating disputes within the Muslim community, but also between the different Jewish tribes and the Christian community as well. And that legacy lends itself to a historical precedent for providing these types of ADR resolutions. And you see this again formalized in different Islamic law treatises in different communities over a millennium. Specifically, my paper addresses what's happening here in the United States with the rise of particularly the immigrant and Muslim community since the 60s and 70s, where you begin to see both institutional disputes as well as family law disputes. And I can tell you, as someone who has litigated mosque disputes and divorce cases, I'd be happy to deal with a divorce case any day over mosque disputes. Mosque disputes can be extremely contentious, very personal, and they can last a very long time. And as a result, historically, what would happen is typically you'd have an elder in the community or a scholar or an alim who would be assigned to help mediate a dispute between different factions that go on. And historically, it was completely based upon a person's reputation, standing, and even I would say charisma in the community. And that was what happened in the 70s and 80s up until the 90s. But as you begin to see more institutions growing, the institutions becoming more sophisticated, and of course, the growth of lawyers in the Muslim community, you find that this role of the sort of the arbitrator in an informal sense, based upon the religious standing, reputation, and charisma really could no longer function. And therefore, you begin to see a more recent attempt by attorneys to try to formulate a process to try to either adjudicate in terms of mediation or arbitration. In fact, this has become more so because of the fact that informal mediations and arbitrations that were actually done and were even formalized into an agreement of resolution were challenged in courts. And there's a famous case both in Indiana, in which an attempt by various members of institutions conducted a mediation arbitration and ultimately led to a written agreement, which was challenged in court and ultimately held unenforceable. A similar occasion occurred in a community dispute in Rochester, Minnesota, which ultimately was upheld because they really took pains to formalize everything with notice, et cetera, and due process and so forth. A famous case in Illinois, which actually went to the appellate court, involved an imam, which served as an mediator, arbitrator of a divorce dispute between a couple. And this imam basically took on the role of judge and jury and decided that he would take on the role of determining whether to grant parenting rights or custody to the couple based on his own determination, not on the facts on the ground, not in the best interest of the children, for example, which is the standard in most states. And as a result, that decision by the imam led to an appeal which overturned the entire divorce case in Illinois. And as a result of these kinds of examples, you're beginning to see now more of this formalized ADR approaches in the Muslim community. And really going forward, what's going to be needed is more training people involved in ADR procedures, whether they're informal or formal, and understanding the law, whether it's contracts, whether it's not-for-profit law, or if it's the law of family law. Having more credibility in terms of an organization's ability to engage in fair, open, transparent, and due process procedures put into place to make sure that it achieves the goals and success for this process.
Thank you so much. Sorry, I'm sorry. Just sorry to interrupt, just because we have 7 people on the panel, so I'm gonna I'm so sorry to interrupt.
No, I'm done. I'm done. So that's fine. Thanks. Thank
you so much. I'm going to move to our third speaker, which is P. Brian Noble, CEO of Peacemaker Ministries, discussing technology in service of biblical dispute resolution, the Peacemaker app, and a conversational approach to effective reconciliation. Thank you so much.
Thank you for having me on. I'm Pastor Brian Noble, CEO of Peacemaker Ministries, and I'm going to introduce you to an app that will walk you from beginning to end through conflict resolution. And so I'll share my screen here. You can go to your Google Play Store or your Apple App Store and download the Peacemaker Ministries Lite app. You can see it here on my screen, and it's going to take you through a conversational approach to biblical reconciliation. The front page that you go through, you can see a lot of information. Start navigating conflict. We're going to dive into that in the next 4 minutes. And then we'll look at insightful frankness. If you need to fire someone, this is a great way to go on that path. How to reboot, my new book, a couple of the books there. But I want to go down here because we also have our founders' information on this app as well. Ken Sandy, who will be a presenter later on today. So check that out. It's a great place for resources. It's free. It'll get you going. So how this app works is both parties would download the app and kind of do their homework ahead of time, prepare their hearts for biblical reconciliation. They hit start navigating conflict, and we'll just do the simple path today, given the time frame. They lay out the ground rules. When they've done their homework, then they're going to get together. They're going to lay out the ground rules that they're going to be polite, kind, and thoughtful, and then they'll agree to healthy tension. And the healthy tension is that we're going to respect differences and that we are going to agree to ask clarifying questions. Then they have the 7 storyline questions, and these 7 storyline questions help them have a discussion. It's like I'm sitting next to them, asking them the questions. Who's involved in the conflict? What's your perspective? What's your motives? Now, what we know is oftentimes in the questions, it's hard when you're one-on-one with each other to have these kind of conversations. And I look at someone and say, hey, what's your motive? But if the app directs us to that, it de-escalates the environment that we're in. So we have past hurts, hopes, outcomes, these kind of things. And so they go through the 7 storyline questions, and the Bible says that we are to be quick to listen, slow to speak, and slow to anger. And so the whole goal is to slow down, although I'm talking very fast right now, but to slow down and to listen to the other person. Then they're going to go back to their biblical core values. And this is where they remember the Father's presence, the Father's character, our identity in Christ, and our calling to be peacemakers. So it walks them through, and they remember their biblical foundation as they go. They take personal responsibility for their contribution to the conflict. In this particular simple version, we have the log and speck tool where they look at the log in their own eye versus the speck in their brother's eye. And then finally, they make and implement a plan. So they come up with how are they going to confess, apologize, forgive, and what's the plan moving forward. Now, something that may interest this panel is if you go into this, start navigating conflict, we also have Peacemaker Ministries' formal mediation process. We do this for full disclosure to our clients so that they know what we're going to go through. It gives them all of our legal documents that we'll be using, all of our requirements. There's nothing that's caught off guard. It talks about abuse, grievances, and those kind of things as we go through it. And so I want to encourage you to download the Peacemaker Ministries app, think through the context of how you might use this in your daily life, because we know that we can simply come to a place where we can have conversations that bring peace to our most intimate relationships. And so our goal and our mission at Peacemaker Ministries is to assist and equip every Christian and every church to respond to conflict biblically. And the only way that we knew how to do that is put it on people's phones. So that's how we did it. We said, hey, let's get it on their phone. Let's get them having conversations so that they don't have to go to a full-fledged arbitration. I am a Peacemaker Fellow, and I enjoy doing those kind of conciliations, but I'd much rather they work it out way ahead of time than have to go through a long process that breaks families, breaks down churches, and breaks down communities. And so that is the Peacemaker Ministries app. Go to your Google Play, Apple App Store, and you can download it today.
Thank you so much. Our next speaker is Sean Momin, Executive Officer for the Aga Khan International Conciliation and Arbitration Board, on promoting the peaceful resolution of disputes in the Shia Ismaili Muslim community, a holistic approach.
Thank you, Dr. Freer, and thank you to the organizers for the invitation. So throughout its history, the Shia Ismaili Muslim community, known as the Ismailis, has maintained a tradition of resolving disputes and differences peacefully through mediation, conciliation, and in some cases, arbitration. This tradition is underpinned by Islamic principles of brotherhood, unity, equity, forgiveness, and justice. And as we've just heard, it stems from the Quran to the teachings of Prophet Muhammad, may peace be upon him, and the Imams. Now, in 1986, His Highness Aga Khan, the 49th hereditary Imam, spiritual leader of the Ismailis, established a global institutional framework of conciliation and arbitration boards, more affectionately known as CABs, to provide Ismailis a formal forum to resolve their disputes. Now, the primary objective of the CAB system is to resolve disputes in an efficient, confidential, and culturally sensitive manner. And this also includes facilitating post-dispute healing so that parties can look to the future with hope and confidence. Now, as a faith-based dispute resolution system, CABs are uniquely situated to appeal to the parties' commonalities, which is their commitment to live within the ethics of Islam. The CAB system recently introduced in its mediation training how to create an ethical culture of mediation. In other words, creating an enabling environment for parties to resolve their disputes that are consistent with key universal ethical principles such as harmony, integrity, dignity, empathy, fair dialogue, collaborative engagement, equity, and healing. This allows all mediation participants, including the mediators, to work together in good faith and with a view to achieve fair and ethical outcomes. Now, CABs also coordinate and collaborate with other Ismaili institutions to promote dispute prevention and to address systemic issues and trends of disputes. These institutions are responsible for the socioeconomic well-being of the community in areas relating to economic planning, health and social welfare, education, and legal support. One example of this coordination is where CABs collect and share root causes of disputes with other Ismaili institutions so that they can take appropriate dispute prevention measures for the community. Finally, another example of how CABs provide a holistic approach to conflict resolution is through their monitoring and evaluation process. Essentially, CAB mediators follow up with the parties after the mediation, and regardless of settlement, to determine, among other things, their satisfaction with the outcome and the process, the status of the parties post-dispute, and whether the mediation has helped them move beyond the dispute in a peaceful manner. This process of monitoring and evaluation further allows CABs to develop strategies aimed at improving the quality of their services and to evaluate and strengthen our services to ensure they adapt to the needs of the community. It also helps CABs determine whether they are actually helping parties bandaging their wounds as a result of the dispute, and then where appropriate, refer them to sister institutions for additional support. As you can see, and we've all heard from different faith traditions, but in Islam, faith and ethics play a significant role in the peaceful resolution of disputes. When we view each other as brothers and sisters and commit to working together to achieve an equitable and just outcome, we are more likely to maintain unity and harmony in our relationships. Thank you.
Thank you so much. Next, we are pleased to welcome Rabbi Shlomo Weissman, Director of the Beth Din of America, who will be speaking on secular law and equity in Beth Din decisions.
Thank you. Thank you to the organizers and to all the panelists. Rabbinical courts, or Batei Din, are frequently called upon not only to mediate, but to actually arbitrate and issue binding decisions in commercial cases. It's ironic that the two most common legal doctrines that we use when doing so are methods that pull away from Jewish law. First, our dayanim, our arbitrators, commonly look to minhag hasochrim, or local law or custom that can be at odds with Jewish law as the governing law of a case. And two, we'll often use a concept known as pshara hakrova ladin. Pshara literally means compromise, like the kind you'd find in a mutually agreed upon settlement. The Talmud loves compromises because they're peaceful. But in this context, pshara means something closer to common law equity, an adjustment or a correction that arbitrators will incorporate into their ruling to avoid a harsh letter of the law outcome. Why are these two things, adoption of local law and equitable assessments, so ubiquitous in rabbinical court rulings? It's because they solve a problem inherent in religious arbitration. One of the necessary elements of a functioning legal system, we know, is adaptability. Legislatures react to changing markets and changing societies by passing laws that speak to the moment. Courts roll with the times. Now, in the very old days, Jews had a commonwealth, and so things went well. It was easy then. Even through the Middle Ages and as late as the 1700s, Jews lived in closed and autonomous communities. There was a structure of legal authority. Communities could band together and they could pass enactments that addressed pressing business and other concerns. But you could see the problem coming. The French Revolution and Napoleon and emancipation changed everything, starting in Western Europe, and then over the next 100 years, slowly rolling through Eastern Europe as well. Ghetto walls started to come down. Today, even when both the party and the counterparty are perhaps both religiously observant Jews, they'll conduct their business affairs utilizing tools of secular society, limited liability companies, joint venture agreements, employment agreements, contracts of every variety. So how on earth, how do you use a religious legal system that's untethered from any specific time or place or society or market, no hierarchy, no legislature, no centralized court system? If a Beit Din simply overlays classical Jewish law to modern transactions in every case, you're going to get unexpected and inequitable results. Every veil will be pierced. Every futures contract will be thrown out as overly speculative. Can a contemporary Beit Din then deliver just outcomes in complex business cases and at the same time faithfully apply Jewish law? Thankfully, our ancient system of law, with its reputation, perhaps rightfully earned, perhaps not, of rigidity and formalism, is really actually very versatile. Minhag HaSochrim, the idea of incorporating local law, is rooted in contract theory, where we can reasonably presume that parties entered into a transaction with the expectation that marketplace norms and local law will govern their dealings. Jewish law will respect that agreement. And when it comes to pshara or equity, there's a fine line, of course, between equity and judicial freewheeling, but properly limited, equity is an important part of rabbinic dispute resolution. These and other ancient methods are valuable tools in a Beit Din's arsenal. We use them regularly to ensure regularity, equity, and justice in the cases that we decide.
Thank you so much. And our sixth panelist, I warned you this was the longest panel, is Abed Awad, attorney and founder of Sharia Wiz, presenting a proposal for a Muslim American Alternative Dispute Resolution and Mediation Center. I believe you're on mute, sorry. If you could unmute yourself. Yeah, there you go. Thanks.
Okay, great. Thank you very much, Courtney. And thank you for Canopy in the center, and a special thanks to Leanne for organizing this. Leanne and I, we worked together, and you'll see the published piece shortly, on a framework that we believe is required for a successful Muslim American Mediation Center. As my other panelists, Shan and Azam explained, that Islamic law has a rich history of mediation and alternate dispute resolution. Unlike the American adversarial system, the pre-modern Islamic judicial system, it deferred to mutual settlement and resolution as a first course of action. Because disputes among Muslims have consequences on extended families and community relations. If disputes are not managed properly, tensions are not calmed, the disputes will create communal disharmony. So the objective of the Sharia, the objective of Islamic law, is to resolve these disputes to provide litigants with a win-win framework. It's not a winner takes all approach, and it's about maintaining communal harmony. So it's all about the community. We looked at the existing mediation centers, and we decided, Leanne and myself, that there are 3 building blocks that are required for us to have a successful and viable Muslim American mediation center. And those building blocks are the applicable substantive law, something extremely relevant to what the rabbi from the Beit Din just discussed, applicable procedures, including some reasonable discovery, and arbitrator and mediator competencies. I'm just going to focus on the issue of the substantive law. What law would the mediator arbitrator apply in a Muslim American family dispute? Now, under American law, all assets acquired during the marriage are marital assets or community property assets, whether 50-50 under a community property regime or distributed equitably under the equitable distribution regime. Unlike in pre-modern Europe, where the property of the wife had merged with the property of the husband, under classical Islamic law, a Muslim woman had independent legal status, which meant that any property that she acquires was her separate property. The husband had no legal or equitable claim to that property. And the same applied, that the husband's property would be his separate property. However, the wife would have a support claim against his property. Now, this was a revolution in pre-modern period where a woman has independent legal capacity, so it's intended to protect Muslim women. But today, the circumstances in the mode of production and economics in the United States, that had turned this concept upside down. So when we talk about what substantive law are you going to apply If you're applying classical Islamic law, this is going to be problematic for most spouses litigating. It may even be contrary to public policy and not even enforceable. We go to even the next step about custody. With the pre-modern child custody, it involved a age-specific, gender-specific criteria to determine who the parent would have rearing guardianship, and the father would be the legal guardian by operation of law. There were good reason for organizing the custody arrangement in pre-modern times, but this would be contrary to public policy if it's applied in a arbitration setting. So here is the issue, is that we have to take into account that the substantive law for a sustainable mediation center would either be applying secular law, which may be objectionable, but rather to apply a modern, organically developed Islamic family law, a jurisprudence anchored in the Quran and the Sunnah, but formed and based on the current social and economic realities of living in the United States. For example, in the 10th century, Maliki scholars had noticed an inequity relating to divorce settlements and inheritance, where a wife was actively involved in working at the family business or at the family farm, and then not receiving her fair share. So they applied the methodology of the Sharia as a knowledge production moral system to remedy the injustice. They created a cause of action called al-kadwa si'aya. In the Maliki school, that means that any woman, wife, who contributes to the acquisition of the marital estate would have an equitable claim in addition to her black letter law rights under the Sharia. So under this theory, you could see that the Sharia is a methodology that produces knowledge, that is flexible, and the success and the fairness of the center will depend on this substantive law that is anchored in the specifics of the financial and non-financial realities of Muslim Americans in the US. This does not mean by any stretch of the imagination that Islamic family law has to become more American. This means making Islamic family law more in sync with the actual social and economic circumstances of Muslim Americans, the underlying objective of the Sharia. Thank you.
Thank you so much. I don't see our seventh panelist, Professor Singh, online. So I think we'll move on to the next panel. Thank you so much for all of your fascinating input and for allowing me to cut you off as you were giving brilliant remarks. So thanks so much.
Good afternoon. My name is Justin Latterell, and I'm the Director of Academic Programs here at Emory's Center for the Study of Law and Religion. Today's third panel is entitled Enforcing Religious Arbitration and Conciliation Agreements under U.S. Law. As we'll hear from our speakers, this is an important and timely topic. Two of our panelists will be discussing a high-profile case involving the Church of Scientology. We hope to publish a third presentation and corresponding article by attorneys representing the Church of Scientology at a later date. Our other two panelists will be addressing broader questions about whether and under what conditions contract clauses that bind parties to religious dispute resolution are legally and/or morally appropriate. Our first speaker today is Dr. Brian Hutler, a fellow at Johns Hopkins University. His presentation is entitled Two Conceptions of Anti-Establishment: When Should Courts Enforce Religious Arbitration Agreements? Dr. Hutler, welcome.
Great. Thank you so much, Dr. Latterell, and thank you to the Canopy Forum and Dr. Bambach for inviting me and for organizing this event. Okay, so I'm interested in the relationship between religious arbitration agreements and constitutional religious freedom protections, especially the Establishment Clause of the First Amendment. And I've explored the argument that religious arbitration agreements might be in some tension with at least one strand of Establishment Clause doctrine, namely the idea that the government should not delegate a governmental function to religious organizations. So this principle was expressed by the court in Larkin versus Grendel's Den, a case in which the Supreme Court struck down a state law that delegated enforcement obligations of a liquor license law to religious organizations. The court appealed to a similar principle in Curious Joel, a case in which a state law would have delegated the operation of an entire public school district to a Jewish community in New York State. Now, one might argue that a secular civil court's enforcement of a religious arbitration agreement is a delegation of governmental function in an analogous sense. By enforcing a religious arbitration agreement, the court forces the parties to take their dispute before the religious arbitrator, generally over the objection of one of the parties. That's typically why the dispute comes before the civil court. As such, the court delegates its responsibility to resolve civil disputes to the religious organization, and it matters for Establishment Clause purposes that the arbitration is religious, not secular. That is, it's different from the cases in which the court delegates its responsibility to a secular arbitrator. However, it could be argued in response to this line of thinking that courts ought not to weigh in on legal disputes that turn on questions of religious belief or doctrine. That point has come up already today. That's another general principle found in Establishment Clause doctrine. And so perhaps when entering into a religious arbitration agreement, you might argue that entering into such an agreement suffices for at least some parties, or in some cases, to make what would have been a secular legal dispute into a matter of religion, whose resolution properly turns on a religious question. And if that's correct, then courts should enforce religious arbitration agreements in keeping with the religious question doctrine. I'm not completely convinced that that's correct. I think that in addition to the concern about delegation of governmental functions, the Establishment Clause also requires that for certain, at least core governmental functions, when religious organizations also perform these functions, the government must ensure that all people have a meaningful secular alternative. Are you trying to cut me off? I'm sorry. Okay, I'm almost done. That all people have a meaningful secular alternative to these religious providers. I call this the voluntariness principle, and the court has expressed this concept or something like it in Zellman versus Simons-Harris, a case in which the court upheld a law allowing school choice vouchers to be used at religious schools, but only on the condition that secular public school alternatives remain available for all students. Now, the voluntariness principle suggests a different sort of Establishment Clause concern. For parties who wish to avoid religious arbitration, enforcement of religious arbitration agreements leaves them with no alternative to religious arbitration. So I want to suggest that this principle may raise at least some Establishment Clause concerns for enforcement of religious arbitration agreements by courts in some contexts. To be clear, I think that even if something like that argument is correct, there are still many contexts in which religious arbitration agreements should be enforced, especially when the underlying dispute really does in fact turn on genuine religious questions that secular courts should not resolve. And generally, I think that if there were no prior objections or any evidence of unfairness in the arbitration process, then decisions made by religious arbitrators pursuant to a complete and fair resolution process should be enforced by courts, as it were, after the fact. So in conclusion, thank you for listening. And I hope that you'll accept that my notes of skepticism here are offered in good faith and in the overarching spirit and value of religious freedom in our society. Thank you all.
Dr. Hutler, thank you. Our third speaker on this panel is Professor Michael Broyd from the Emory University School of Law. His presentation is entitled, "There is no First Amendment exemption in contracts generally or in the Federal Arbitration Act. There is no First Amendment exemption. It would be poor policy and maybe unconstitutional to have one." Professor Broyd, welcome.
Thank you very much. I think the previous presentation was talking about me, but that's okay. I think that whether or not we allow somebody to sign an arbitration agreement in an amusement park that governs their post-amusement park conversations should be identical to the question of whether we allow such in Scientology. And to me, there's three basic objections to the California Court of Appeals decision in this case. Scientology, the Court of Appeals says, written arbitration agreements are not enforceable against members who have left the faith with respect to claims for subsequent non-religious tortious acts. Told otherwise would bind members irrevocably to their faith to have a constitutional right to leave. The Court of Appeals said here that an amusement park has the right to compel you to go to arbitration, but a church does not. And that is exactly my objection. This opinion is thrice wrong. It's inconsistent with the Constitution. It's inconsistent with federal law. and it defies common sense. It's inconsistent with the Constitution because the court has said many times that secular and religious institutions need to be treated on the same playing field. If an amusement park can take you to arbitration, so can a church. It's inconsistent with the Federal Arbitration Act because the Federal Arbitration Act requires that states enforce arbitration agreements. And it makes no distinction between religious or secular arbitration agreements. And whatever is the rule for an amusement park is the rule for a church. And more importantly, it's inconsistent with common sense as well. People are allowed to make agreements that bind them in ways that law cannot compel them to be bound. The simple fact is that people come to an amusement park and they decide, do they want to sign the arbitration agreement and be bound by its provisions or not? And the same thing is true with the church. The general contract defenses, duress, unconscionability, apply all the time. Imagine a baker who contracted to bake a wedding cake for a same-sex wedding and then discovered in their faith that they objected to this cake only after they signed the contract. Who wants to let people get out of contracts because they have a good faith religious exemption to a contract that they signed already? It is crazy making and opens contracts to a very subjective faith test that further frays the neutrality of law in an area of law that ought to be exceedingly, exceedingly neutral. The time for people of faith to examine a contract is before they sign it and not after they sign it. And all of us sign agreements that we subsequently regret, and contract law should not allow us to back out merely because our faith disagrees. Let me add, by the way, that I have no problem with Congress prohibiting all arbitration in a field, like Congress recently did for all pre-dispute contracts of arbitration in sexual harassment. But I just don't want to let I don't want to let the law draw a distinction between an amusement park and a church. Thank you all very much. And thank you particularly to Leanne for organizing this conference.
Thank you, Professor Broyd. Finally, I'm pleased to introduce our final speaker in this third panel, Mr. Ken Sandy. Mr. Sandy is the founder of Peacemaker Ministries and Relational Wisdom 360. His presentation is entitled Reversing Course on Conciliation Clauses. Mr. Sandy, welcome.
Thank you. Yeah, it's really a privilege to be here. I am learning an awful lot about a topic that is of great interest to me. For the past 30 years, I've encouraged churches, ministries, and Christian-owned businesses to use legally binding conciliation clauses in their contracts, bylaws, employee handbooks, and church membership commitments. And our standard clause commits the parties to 3 levels of resolving a conflict: personal conversations, if that doesn't work, mediation, and if that doesn't work, arbitration. My support for these types of clauses came from my reading of 1 Corinthians 6, 1-8, where the Apostle Paul exhorted early Christians to resolve their conflicts, including their legal conflicts, within their churches rather than turning to the civil courts. And these types of conciliation clauses are now in use in thousands of such documents, and they've resulted in countless conflicts being resolved in a conciliatory manner within the community of faith rather than an adversarial manner in civil courts. Now, these clauses have occasionally been challenged in courts, but have almost always been upheld. The primary goal of these clauses is actually to remind people to respond to conflict in a way that's consistent with their religious beliefs, which ideally begins with personal efforts, sitting down one-on-one to resolve the conflicts rather than jumping immediately into mediation or arbitration. And for example, one Christian architect who uses these in all of his contracts told me that since he started using them, he's never even had to call his attorney, because every time he's had a major dispute where he would have called the attorney, started a legal process, he was reminded, hold it, I agreed to resolve this in a biblically faithful way. That means meeting with the other person, getting the log out of my own eye, resolving it. And he said he hadn't had a situation go even to a mediation process since then. So in light of these benefits, I continue to encourage the use of these conflicts or these clauses between parties with equal bargaining power. Now that's important, equal bargaining power, such as two commercial business owners who share similar religious beliefs. But in spite of the many positive uses of these clauses, I've recently decided I can no longer recommend that churches and other religious organizations use legally binding conciliation clauses in their membership agreements. The reason for this change is that I've learned of some unscrupulous church leaders using legally enforceable clauses to oppress members who asked unwanted questions or declined to support questionable policies or practices. Religious arbitration clauses can be especially repressive when they're deliberately designed to favor one party over the other, as our two previous speakers talked about. Now, we've got lots of safeguards built into our rules of procedure to prevent that kind of bias or imbalance. But even in spite of that, I've grown increasingly concerned about how these clauses can be used by religious leaders in appropriate ways. For example, they could have church members sign these clauses without even realizing what rights they're giving up. And then later on, when a conflict comes up, they feel like they're being dragged into a process against their will. So in light of these concerns, I now recommend that churches and ministries use informal commitments to Christian conciliation in their churches and their bylaws and commitments rather than legally binding clauses. For example, a clause in a membership covenant might say, if I have a conflict with another member or a leader of this church, I commit to making a sincere effort to resolve it according to the peacemaking principles set forth in Scripture. If we're unable to resolve a conflict through personal conversation or informal mediation or through the established disciplinary process of the church, I agree to give prayerful consideration to resolving the matter through a more formal conciliation process as described in these rules. That process is not a legally binding process, but it still reminds parties of the commitment to try to resolve things consistent with their faith. And I think that's more consistent with the biblical principles of loving our neighbors and treating other people as we'd want to be treated. Thank you.
Thank you, Mr. Sandy, and thank you to all of our panelists. We'll now go to our next panel with moderator Alexa Windsor.
Good afternoon, everyone. I'm Alexa Windsor, and I'm receiving my LLM here at Emory. I'm working on applying these faith resolution models to the LGBTQ community, and that'll be my future academic track. We now reached our final panel here, which examines the challenges confronting religious arbitration and dispute resolution. This panel focuses on how to protect vulnerable parties by limiting the possibility of oppression and managing power and abuse dynamics. We'll also discuss the risk that so-called anti-Sharia laws pose, not just to religious arbitration by Muslims, but to all religious communities. I'm pleased to introduce the first speaker on this panel, Professor Rabia bin Halim of the University of Colorado School of Law, speaking on limiting oppression, duress, and unconscionability in Islamic law. Thank you.
Good afternoon. I'm delighted to be here with you today. I'll be discussing the equivalent doctrines of duress and unconscionability as they apply to Islamic law. Now, you may be wondering why I'm discussing these doctrines in the context of religious arbitration, and I'm doing so for a couple of reasons. First, when we look at the discourse from the anti-Sharia movement in both North America and in Europe, we find a presumption that Islamic law cannot or will not protect vulnerable parties, and that by de facto, secular civil courts will always protect vulnerable parties better than an Islamic arbitral body. I'm here to challenge that presumption. The second reason I'm discussing these two doctrines is in regards to something called delegation clauses. We increasingly find here in the United States delegation clauses present in arbitration agreements. And per the Supreme Court decision under first options and subsequent decisions by the court that have upheld the first options decision, if there is a delegation clause present within an arbitration agreement, the review of the enforceability of that arbitration agreement itself, including review of possible unconscionability or duress, would fall to the arbitration body that was designated rather than to a civil court. So part of the question I had in mind when I looked into this topic was, well, if there's a delegation clause present within a Muslim arbitration agreement, what would the review of possible unconscionability or duress look like if Islamic law was applied? And indeed, unlike the presumptions that we find within the anti-Sharia movement, Islamic law does in fact have protections of vulnerable parties. Those protections that are found within Islamic jurisprudence are primarily derived from a series of Quranic verses. These verses from the Quran include, "O you who believe, fulfill your contracts or covenants. O you who believe, do not consume each other's wealth or property between yourselves illegitimately. Do not devour one another's possessions wrongfully, not even by way of trade based on mutual agreement. Do not destroy one another. Indeed, God orders justice and beauty and giving to relatives and forbids immorality and abomination and oppression." Muslim jurists, based on these verses, built jurisprudence that condemned bargains that they deemed oppressive and unfair. They developed a number of different principles, such as the doctrine of unjust enrichment, contracts of necessity, and prohibitions against excessive speculation. In particular, as regards unconscionability, the concept of riba was important in providing protections for vulnerable parties. You may be familiar with the concept of riba as it regards Islamic finance, but the concept actually has far more broad-reaching implications than simply finance. Really, there's two different types of riba, and scholars have differentiated between them. Riba, in which a contracting party acquired an unlawful excess profit, and the riba in which a party used contract terms to gain an unlawful advantage by speculating on uncontrollable risks. Under the common law, quite a lot of agreements that are generally permitted would actually be prohibited under Islamic law due to economic exploitation. Additionally, Islamic law within the equivalent doctrine of duress or coercion takes into greater consideration the subjective experience of a victim than would be found within the common law. Islamic law takes into potential consideration a person's economic class, gender, geographic location, or age, rather than just taking the reasonable person standard, which is slowly changing within the common law. Islamic law really brings a more particularized evaluation of a victim's experience. In short, I argue that parties that find themselves in American Muslim arbitration can find greater protections through the application of the Sharia against oppression and exploitation than they might necessarily find with the application of common law in a civil court. Thank you.
Thank you. Our next speaker is Daniel Teeter, president of Love at Peace Ministries, on managing power and abuse dynamics.
Thank you so much. It's a pleasure to be here with everybody today. Christian conciliation, as my fellow panelists Ken and Candy, Brian have already shared, is a wonderful and effective tool that assumes a dynamic of mutuality, equality, neutrality, and joint responsibility to help resolve conflicts in a biblical way. Yet, much like other models in alternative dispute resolution, when there is a significant power imbalance, a good tool that effectively addresses mutual conflict can actually become an instrument of potential harm. Therefore, I argue that it's unwise to use standard conciliation methods when there are significant power imbalances due to abuse, because it puts victims at risk for re-traumatization. I believe it's the conciliator's professional responsibility to grow in their awareness of power dynamics within a conciliation process in order to avoid putting vulnerable parties in harm's way. Because power dynamics exist in all social relationships, power inequities and imbalances occur frequently. These imbalances are often natural and morally neutral. Power is not inherently evil, and it can be the source of great good if it's motivated and constrained by love. And furthermore, as some have argued, having an exactly equal power dynamic in a mediation isn't necessarily required for it to be fair, nor is this entirely possible because of the subjective experience of interpersonal power. Moreover, having a stronger party doesn't inherently mean they will abuse that power. Yet, there are power imbalances that can create a context for harm if left unnoticed and unchecked. Mediators, unfortunately, can inadvertently exacerbate an existing power imbalance by imposing impartiality on an unlevel playing field. In most extreme cases like abuse, it's not simply that there is an imbalance of power, but the intentional exploitation of that power imbalance to expand the control of the abuser that comes at the expense of the victim. A litmus test for assessing power imbalances is how this imbalance affects a party's ability to self-determine. This can be observed by examining a party's capacity for meaningful action in their negotiation interests. However, it also can be observed through a party's experience of fear, retaliation, punishment, or threat. I recommend a three-pronged approach for conciliators in developing a more helpful path forward to address power imbalances caused by abuse. First, a conciliator must assess power dynamics wisely. This means starting with a foundational understanding that there are power dynamics in every conciliation. I recommend building in a standard set of questions as a mediator conceptualizes the case, whether it's through an intake process or in their actual case conceptualization model. I also advocate strongly to use screening tools that will surface these power dynamics, particularly ones that are imbalanced due to abuse. Once you've identified power imbalances that are in play, I recommend that you accommodate these power differentials appropriately. Accommodation of power differentials starts by identifying and seeing the vulnerability of the party most at risk. It means informing parties of the risks of participating in a conciliation process, informed consent, particularly if an abusive individual or group does not acknowledge their abusive behavior. It also will mean changing the format of the conciliation process entirely to better reflect the nature of the harm that has occurred. For example, a restorative justice model could be one approach. Lastly, I recommend that conciliators advocate for justice, which might sound a bit odd, given that we are to remain neutral in the sense that we are unbiased, fair, and do not demonstrate favoritism and provide a consistent process. However, I believe it's legitimate to consider that neutrality creates complicity to harm when injustice and oppression are occurring. So advocacy begins by shifting the focus from conflict-oriented reconciliation to naming and identifying the abusive patterns and constructing a trauma-informed process that is victim-centered. So although cases involving power imbalances are quite complex and challenging to navigate effectively, and certainly I could say much more, as I'm sure all of us could, I believe that with the proper approach, we can successfully serve victims by adopting best practices that empower them to flourish. And I appreciate the time, and thank you for having me.
Thank you. Next, we have Ann Carey, an attorney and Christian conciliator, whose presentation is called Women, Power Imbalance, and the Alternative Dispute Resolution Process.
Well, good afternoon, everyone. I am having some technical issues here, so I hope everyone can hear me. I appreciate and have thoroughly enjoyed the opportunity to be here today. I feel like I'm going to ditto a lot of what was just said regarding power imbalances in the Christian conciliation process. I think we can all acknowledge that conflict is a part of life, and generally not a very pleasant experience. And there are those that, at least in my experience, when they come to the conflict resolution table, they come as if they're walking into a gladiatorial arena. It's a win-lose situation for them. But among the Christian community, that should not be our approach. Our approach to the dispute resolution process ought to be one that is wise, discerning, fair, and equal in our treatment of all of the parties. We ought to strive for a result that is reasoned and biblical. It is true, and I think we acknowledge that male leadership of pastors and elders is considered by many Christian churches as a biblical principle, but that's not what we're discussing here today, or at least not what I'm discussing today. The biblical principle of treating all people with equal value is what I think is really important and what I want to address today. The principle is not to be ignored in any type of hearing, conciliation, or mediation process. God created us all equal. On a deeper level, when a power imbalance exists at the conflict resolution table, it may be used to threaten the disadvantaged party, whether it's male or female. The ability of anyone to coerce, control, abuse, or intimidate a party during the process does not allow for a reasoned, fair, and balanced result. Those of us who serve in the Christian community must be aware and be prepared with a plan to address imbalances that are used improperly before the process begins. Of note, we must not ignore power struggles between those in leadership who may have their own agenda or their own fellow relationships. When a woman is a party to a dispute, being surrounded by an all-male decision makers does not create feelings of a safe environment. To reiterate, applying biblical principles of equality, justice, righteousness, and reasonable resolution to the conflict requires recognition and a plan to manage or address the power imbalances. An imbalance may be resolved simply by bringing a skilled, perceptive woman to the table, a woman with the maturity and the courage to speak out for the disadvantaged party, male or female. The subject matter in dispute doesn't really matter. One must never assume equality between the contending parties. Throughout history, women have played significant roles in conflict resolution. Two names that were mentioned in my essay are Harriet Tubman, a courageous and spiritually sensitive woman that led hundreds of slaves to freedom, and Deborah in the scriptural report in Judges chapter 4. She was a prophetess, a warrior, and victoriously led Israel's army into battle. Her biblical history can be found at the entire history can be found at Judges 4. And one of the things that I wanted to make note of sitting here today, we all recognize cultural and religious differences between the various communities. However, my challenge to those who are not constrained by any particular reasoning or law and are involved in religious conflict resolution forums is to intentionally strive to provide safety and equality between the contending parties. Advanced investigation, as Daniel mentioned, abuse screening questionnaires, being trauma informed, and perceptive listening is really critical. They all help to provide a fair and reasoned outcome. If power imbalances are detected, please make a plan for management and safety. And thank you again for the opportunity to be here today.
Thank you. Our fourth panelist, Usma Udine, is a visiting professor at Catholic University's Columbus School of Law and a fellow at the Aspen Institute. Her presentation is entitled "The Danger of Anti-Sharia Legislation to Religious Arbitration and Not Just by Muslims."
Thank you. Over the past decade or so, a raft of bills has been introduced across the country that purport to protect the US legal system and even Western civilization itself from the dangers of creeping Sharia or Islamic law. These anti-Sharia laws do nothing to actually stop the imaginary Sharia swamp creature from contaminating the US. Rather, their legal effect has been to intervene in the rather humdrum matter of how people of faith, whether they be Muslim, Christian, or Jewish, can resolve their family affairs, business disputes, and internal community matters according to their own religious traditions. The first generation of these anti-Sharia laws singled out Sharia specifically from all other legal traditions and described it as anti-American and treasonous. The second generation didn't single out Sharia, but instead included a number of other religious traditions. For example, an Arizona bill stated that courts cannot consider, quote, religious sectarian law, and then defined the term to include Sharia, canon law, halakha or Jewish law, and bizarrely, karma. The final evolution of anti-Sharia laws and the most common type of bill simply denies courts any consideration of foreign law, which it defines as, quote, any law, rule, or legal code or system other than the state and federal constitutions, state and federal statutes, and the ratified treaties of the US. The facial neutrality of these laws has enabled them to bypass First Amendment issues, and to date, they have been proposed in 43 states. These anti-Sharia laws don't solve any existing problems, but they do create new ones. Under US law, religious organizations have broad religious autonomy, and religious individuals, like all Americans, have broad freedom of contract. However, the US legal system already has plenty of safeguards built in.
While the US Constitution, specifically its religious liberty clauses, allows for religious arbitration, there are limits. For example, religious arbitration is limited to civil law matters and does not extend to criminal law issues. Religious arbitrators cannot impose physical punishments or overstep the bounds of authority granted to them by federal and state law, regardless of what their religion may teach. Even in certain civil matters, for example, when children are involved, the state tends to exercise a bigger role, and in some cases may even flat out prohibit things like the arbitration of disputes over child arrangements in cases of divorce. And any time an arbitration decision is brought to a court for enforcement, the court checks to make sure the decision is fair by asking questions like, does it violate American laws in any way? Does the decision comply with American public policy? Did the parties submit to arbitration voluntarily? And does the decision unfairly discriminate against one party? Because we already have rules that regulate what religious arbitration can and can't do, anti-Sharia laws add no value. What's more, these broader facially neutral laws impact not just Muslims, but all religious believers who want to use religious arbitration. In fact, Sharia arbitration is rare compared to other types of religious arbitration in the United States. Many Christian and Jewish Americans consider religious arbitration indispensable to a faithful life. For example, Orthodox Jews use the Beth Din of America, a court of Jewish law that helps believers arbitrate disputes through the Din Torah process, obtain Jewish divorces, and confirm Jewish personal status issues. And Christian conciliation provides a framework for parties to resolve a dispute using mediation or arbitration based on biblical principles. What anti-Sharia and anti-foreign law proponents might not have realized is that these broader facially neutral laws impact not just Muslims, but all religious believers who want to use religious arbitration, including Jews and Christians. Thank you.
Thank you. All right, y'all. Today's final speaker, Dr. Leanne Baumbach, is a senior fellow at Emory Center for the Study of Law and Religion and the brilliant organizer of this lovely online conference and excellent essay series. She'll speak on the future of religious arbitration, then bring these proceedings to a close.
Thank you so much, Alexa, for that very nice introduction. As we have heard over the course of this last hour and a half or so, religious arbitration and dispute resolution is well established here in the United States and is practiced in some form by a wide variety of religious communities. On the whole, religious arbitration and dispute resolution systems have proven remarkably adept at adjusting to the requirements of the US legal system, and modern American arbitration law provides a great deal of leeway for religious communities to develop strong, faith-based systems that harmonize between religious and secular legal norms. While such systems may differ in the details, they share much in common: a desire to create an alternative to secular litigation that is not only quicker and faster, but that speaks to the specific needs of their community, a heavy emphasis on conciliation that includes not only the actual parties to a dispute, but which extends outward to promote cohesion and harmony within the wider religious community. And most importantly, a dedication to abiding by what they see as the spiritual imperative or God's will. Looking to the future, I would like to touch on three main points that religious arbitration and dispute resolution must consider in order to keep growing and be fully accepted both within their own religious communities and by American society and our secular legal system. First, as we just heard in the last panel, religious dispute resolution forums must do a better job of recognizing and addressing power imbalances and abuse. It is impossible to resolve disputes in a way that delivers true justice and real conciliation to all the parties if the proceedings are tainted by the presence of a power imbalance or abuse. So religious dispute resolution professionals must be trained to not only look for and recognize the presence of abuse or a power imbalance, but be given the appropriate tools and resources to address them. It is also important to remember that power imbalances can exist not only between the parties, but can be embedded in the dispute resolution process and sometimes in the religious law itself. This disproportionately affects women, so we should make sure women have at least a voice in the system, or better yet, a seat at the table. No religious law or tradition is static, so we can be creative. Second, US law requires that arbitration be entered into voluntarily, and this should go double for religious arbitration. Having parties dragged, kicking and screaming into a religious arbitral forum, as we've heard about in the Church of Scientology case, is bad on several levels. In the judicial system, it can create bad precedent, which, binding or non-binding, is bad for everyone. And in the court of public opinion, it is even worse. Which leads me to my third point. For better or for worse, all the religious communities represented here today are, to a very large extent, in this together. So while of course each has its own distinct set of beliefs and practices, it makes sense to reach across confessional lines and help each other. Not only in bad times, like when anti-Sharia laws or bad press threaten, but also in the good. To learn from each other, to share best practices, to help ensure that religious arbitration and dispute resolution is seen as a legitimate and valued part of American life. So that concludes today's panels. And to all of you watching today from around the US and the globe, thank you for joining us for today's webinar on the promise and perils of religious arbitration. And on behalf of Emory University, the Canopy Forum, our viewers, and myself, may I extend our sincere appreciation to all of today's presenters for their willingness to share with us their experience and insights. Today's presentations are based on articles contributed by each of the presenters, which will be published starting next week on the Canopy Forum, the open access digital publication of Emory Center for the Study of Law and Religion. And many thanks to the people at Emory Center for the Study of Law and Religion and the Canopy Forum who have sponsored and supported this project, especially Justin Lateral, Shlomo Pill, Courtney Freer, Alexa Windsor, Sandra Borden, and Rachel Orbetta, and the Center's director, John Whitty. And special thanks to John Bernal, our Director of Digital Scholarship, who has skillfully managed all the technology that has made this event possible. My thanks and best wishes to all of you.